August 1st, 2014. Nekanen otoka Tupac Enrique Acosta Yautashka Tatoka Nawatalis Kaloteka. Today we are called to address the working group on the Universal Periodic Review of the United Nations Human Rights Council in the subject of the United States of America. This statement is by the Movimiento Macehualli, los Comités de Defensa del Barrio, Tonatierra. Good greetings. In addressing this call for consultation by the U.S. State Department regarding obligations that the U.S. government is obligated to uphold under the standards of international human rights, laws, policies, and practices, we begin with a general comment. As indigenous peoples who do not subscribe to U.S. status as federally recognized tribes, we stand with the position of the Oglala Lakota Nation submitted to the 2014 session of the United Nations Permanent Forum on Indigenous Issues, and we quote, "The Oglala Lakota Nation further rejects the assertions of the United States government as stated in its announcement that the United Nations Declaration on the Rights of Indigenous Peoples calls for a distinct international concept of self-determination specific to indigenous peoples. The Oglala Lakota Nation rejects the fabricated claim of the United States that the Declaration is intended to promote the development of a concept of self-determination for indigenous peoples that is different from the existing right of self-determination in international law." Subsequently, while the U.S. government accurately reports in the 2010 report to the UN Human Rights Council that by virtue of their status as sovereigns that predate the Federal Union, as well as subsequent treaties, statutes, executive orders, and judicial decisions, Indian tribes are recognized as political entities with inherent powers of self-government. We clarify now that the designation of tribes, while consistent with U.S. federal Indian law, does not accurately describe the pre-existing sovereignties of the nations of indigenous peoples of Abya-Yala, also known as the Americas, and our international confederations that not only precede European American colonial governments, but still today continue to exercise our inherent human rights as indigenous peoples, in spite of U.S. government policies and the imposition of international borders of the states. Regarding the recommendations of the Universal Periodic Review in the case of the United States of America, in Issue 1, Civil Rights, Ethnic and Racial Discrimination, our statement. While the U.S. government's role in the defense of civil rights in the state of Arizona has been the focus of litigation in the case of AZ SB 1070 specifically, and the subsequent appointment of a U.S. federal marshal in the case of Melendres versus Arpaio, neither instance has identified the violation of human rights of indigenous peoples as migrant workers with their families. Designation of categories of racial profiling identified for redress in both cases excludes indigenous peoples and only provides relief for the categories of Latinos as litigants, a blatant act of systemic discrimination by the U.S. domestic legal system in denial of the principles and standards of the United Nations Declaration on the Rights of Indigenous Peoples. On the point of the environment, our statement, our inherent human rights as nations of indigenous peoples are founded in the reality of our nationhood and collective responsibility as children of Mother Earth in respect for the territorial integrity of Mother Earth. The position of the U.S. government on this issue of climate change, global warming, and climate chaos is an unacceptable and flagrant denial of responsibility as a mass consumer society to the natural world and the future generations, which constitutes complicity in the crime of terroricide. On the issue of treaties, international human rights mechanisms, our statement, as indigenous peoples, equal to all other peoples, our children must also be acknowledged respected and protected as equals in human rights, most importantly, the right of self-determination. We call upon the U.S. government to uphold the principles and standards articulated in the United Nations Convention on the Rights of the Child, and in full responsibility for the human rights of future generations, we call up full recognition of the human rights of the refugee children arriving at the U.S.-Mexico border as refugees from the illegal colonization of Abya Yala, also known as the Americas, beginning on October the 12th, 1492, with the Doctrine of Discovery, and the subsequent complicity by the U.S. government administrations under the premise of the Monroe Doctrine of 1823, by military intervention and trade policies that make the U.S. government a responsible party to the extreme violence driving the mass migration of children, youth, and families from Central American countries of Honduras, El Salvador, and Guatemala. In the same regard, we denounce the complicity of the U.S. government. In the same regard, in terms of the Convention on the Rights of the Child, we denounce the complicity of the U.S. government in contracting with the government of the Zionist apartheid state of Israel to supply armaments being used at this very moment to massacre the civilian population of Palestinians in Gaza, including an unbearable number of children as victims of state-sponsored genocide. Aye.